This is continuing coverage. The Black Swan murder trial of Ashley Benefield from the Hidden Killers podcast and True Crime Today. Now back to the courtroom.
This is what you just handed out?
Yes.
All right, I've reviewed Henry.
You want me to comment on Britain, case that they just provided?
I haven't read it yet. You can if you want, but I'll probably let them go first. All right, go ahead, State.
Judge, to be honest, we are still going through what they're trying to induce because this is missing pages from the exhibit that they were talking about. So we don't, I can't even speak to exactly what's in that. So I apologize if I get it wrong, what they're trying to introduce. First, Judge, there has to be an overact, yes, regardless of how that's proven. I believe once that is proven, other acts of violence can come in to show that the defendant's apprehension was valid at the time she had to use self-defense. The only way we know that any of these things added to her apprehension is if she says it did. And the case that I just handed up, the Britain case, is an example of that, where there were prior acts of violence, but because they were so attenuated, they were, I believe, 4 years before, and I will read, it's a highlighted portion on page 2 of the case. With respect to the excluded evidence, however, the trial judge found that the unfair prejudicial effect of the evidence substantially outweighed its probative value, considering the prior incidences' remoteness in time, the lack of connection of intent and the crime charge, and the speculative nature of any real connection whatsoever as far as any apprehension in Britain's mind. I do believe that even if the 911 call substantiates some sort of an overt act, which I still believe the defense has to put that in, but even if it does make an overt act, that these items that the defense is trying to introduce are still not admissible because we have not been informed by the defendant or otherwise that any of these things that the defense is trying to get into went into her apprehension and caused her fear and caused her to react the way she did. Additionally, at least from what I could tell from what I think is in the exhibit, I don't believe there are any acts of violence even spoken about in the exhibit. There's language, there's defendant saying to think of you with anybody else makes me crazy. I don't know that those are acts of violence. All of these cases talk about acts or threats of violence. And I don't find that there are any threats in any of this, or there are certainly no acts that are described in this that have happened. So I would say it doesn't meet that requirement anyway as a prior act of violence. And even if it did, I think we have to have some evidence that this, being so many years ago, played into the defendant's decision to use deadly force. So we would object at this point.
Sir?
We expect to call to testify a domestic violence expert. That domestic violence expert is going to educate the jury, in fact, he should educate all of us, about how domestic abuse is cumulative. It builds and it creates this overwhelming anxiety. As the court knows, this entire case revolves around a 4-year relationship. This is the beginning of the insight that Ms. Benefield gains that ultimately and very shortly thereafter leads to her leaving Doug Benefield. And the court may recall, because I shared a letter with the court, that Ms. Benefield left Mr. Benefield when she left him, describing and explaining how she feared for her safety and that of her child being with him. that he was controlling, that he did the following acts, from shooting the gun to punching the dog. The domestic violence expert is going to say all of these things remain in an abused person's mind, so that on the day of the incident, September 27, 2020, despite the fact that it was at the end of the 4-year relationship, that is why the reaction of Ms. Benefield was appropriate or was not unreasonable given all of this prior history. And that's also why the case law that I provided, Your Honor, says domestic violence expert testimony should be admissible for exactly that reason. So here's what's happening, Judge White. The state just introduced 363 text messages and played a video. Why did they do that? They did that to show, because it's the central theme of their case, look how well they got along. In the week prior to the shooting, smiley faces, they're having lunch at the restaurant, everybody looks happy. The domestic violence expert's going to confirm what Dr. Broder told us and what Dr. Quintal told us, is that in the face of an abusive relationship, getting along and going along is always the best course of action that these women embrace, especially when a child is involved, because it is the safest manner to keep the beast at bay. I believe those were Dr. Broder's exact words, keep the beast at bay. So, here is the beginning, where she looks at these messages and she doesn't quite realize the significance of them. But shortly thereafter, once he starts firing the gun into the ceiling and putting it against his head, punching holes in the drywall, punching the dog unconscious, now it's beginning to dawn on her, oh, the guy that I married is not the guy that I thought he was. And now you begin to enter that mentality of abuse. And you begin to develop a survival instinct for it. So that's why you employ the get along, go along, because you do not want to do anything to antagonize the abuser for fear of reprisal. And Dr. Quintal told us exactly that. That Ms. Benefield's concern, and the court may recall it was the state that asked this question. Dr. Quintal, was Ashley Benefield concerned about the release of the Broder report? Remember, Judge, I served it up on the head of a pin. The theory of the state is that Ashley Benefield killed her husband because the Broder report was going to be released 3 days later. Question, Dr. Quintal, by the state. Was Ms. Benefield concerned about the release of Broder's report? Yes. Why was she concerned? She feared a reprisal from Douglas Benefield when and if he learned what she had to say about it. So this is consistent with that syndrome. I think it should be admissible. I think we've established that in the record she says she was attacked and she shot him, and she doesn't just say it. The court's ruled it was a spontaneous statement. She's hysterical. Even the cops described her as hysterical. In fact, one said he thought she may have been in shock.
All right, thank you both very much. Let me clarify, I'm pretty sure the ruling that I made regarding the 911 specifically revolved around Mr. Sant's statements. I found that they weren't excited utterances. I found that they were, some people call them present sense impressions, some people call them spontaneous statements, and therein lay the order. I had specifically, I recall saying that I had not heard about or argument as to the defendant's statements in the background. I remember I said if those were going to be introduced as excited utterances, they would have to be through the witness when he was on the stand. Here nor there was no objection. You could hear certain statements being made in the background of the 911 call. I think both sides are really talking about a macro issue, whereas this issue is much more refined than that. in order to, because I looked as well over lunch to try and find an answer to this particular question, because I think the argument being made by the defense to allow specific incidences of violence or aggression by the victim is new and novel. I think it's fairly unique in arguing that that occurred during the state's case in chief. And I'll start my analysis because I think this is a unique issue. I don't know if it's an issue of first impression here in the state of Florida, but I can say I didn't find a case on it, and neither side has presented a case to answer this question. And so I start my thought process by saying that self-defense is an affirmative defense. So generally speaking, the state must prove its allegations beyond a reasonable doubt. If the defense then wants to assert an affirmative defense, the burden shifts to the defendant to prove, using competent and substantial evidence, that is admissible evidence, by a preponderance of that competent substantial evidence, that she acted in self-defense or acted under duress or necessity or whatever affirmative defense is being asserted. Then the burden shifts back to the state to disprove self-defense beyond a reasonable doubt. And as has been noted by both sides and the court as well throughout, that the case law, and I also start with Smith, which I quoted in a prior order, and this is, again, Smith, 606 Southern 2nd, 641, and this is at 643. Before a defendant may offer either type of character evidence, which is specific act, of course we know that the defendant has to have knowledge of that, or the reputation, which the defendant doesn't have to have knowledge of. And again, I'm reading from Smith at 643. Before a defendant may offer either type of character evidence, he or she must lay a proper predicate demonstrating some overt act by the victim at or about the time of the incident which reasonably indicated to the defendant a need for action in self-defense. And then we get into if the defendant lays that predicate and there's the slightest evidence of an overt act by the victim which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. There's also Warren that we have been discussing. 577 Southern 2nd, 682, and in that situation, the evidence was kept out and the trial court was reversed on that. There, the defendant sought to introduce evidence that Taylor, the victim, was a cocaine user whose habit had grown progressively over time. The defendant testified that when the victim was unable to obtain cocaine, he became violent and argumentative, picked fights. The defendant also testified in that proffer that the victim appeared to be in the throes of cocaine withdrawal and that he was afraid of her. And the proffered testimony was excluded. And I use that as an example, again, to show my line of thinking that, yes, the homicide defendant can get into these things, but there must be that burden shifting and the defendant presenting evidence affirmatively, competent substantial evidence to prove by preponderance that she was lawfully justified in using force likely to cause death or great bodily harm or not likely to do so. Finally, there was one other case in Hedges, which is another case I think we've talked about, is 667 Southern 2nd, 420, and this is at 422 and 423. It's first DCA 1996. And it talks about exceptions to character evidence not being admissible, where evidence of the victim's reputation for violence or specific acts of violence are admissible when the defendant knew of the victim's violent acts or of his violent reputation at the time of the alleged offense. This case is from 96. I think there's other case law now that establishes the defendant doesn't have to know about the reputation for violence, but here and there. That evidence of prior specific acts of violence by the victim is admissible if it is relevant, because it is relevant to reveal the reasonableness of the defendant's apprehension at the time of the incident. However, even Hedges says, before the defendant may offer this type of character evidence, a proper predicate must be laid by evidence of some overt act on the victim's part at or about the time that reasonably indicated a need. So the reason I wanted time over lunch to try and find some cases, if there was any cases that had said that predicate can be laid during the state's case in chief, and I was not able to find it, and I looked at Henry. I was reading Henry that the defense produced to see if it explained factually how the information came in regarding the hand in the pocket, and it doesn't say. It just says that the trial judge excluded evidence And unfortunately, it doesn't give any indication about whether that was during the state's case in chief or the defendant's case in chief.
May I make an inquiry of Your Honor?
I'm sorry?
May I make an inquiry of Your Honor relative to what the
I
court...
guess you can ask, but I'm in the middle of a ruling.
Well, I think it may be relevant, helpful for
Okay.
the court's ruling. I think what the court is saying is looking for some guidance as to the procedural aspect of whether or not this evidence can be introduced during the state's case as opposed to the defense case.
Correct.
Okay, so...
Right, and that's what I'm making my findings about.
Yeah, and the only thing I would say to the court, directing myself exactly to that, is I don't think any of us, would dispute that self-defense is a recognized justification. I don't think any of us would dispute the 9/11 call, he attacked me and I shot him. The only thing I would say to the court is, to the extent Miss Benefield is presumed innocent, wouldn't the court rather want a case that says it cannot be introduced during the state's case in chief, rather than assuming it can? I think the defense is entitled to the benefit of the doubt, and in the absence of case law that says the defense may not introduce this during the state's case, I think we should be entitled to it.
All right, thank you. So I did think it was an interesting issue, so I did the research. And this may be the case that ultimately, if it gets to the second DCA or the Florida Supreme Court, where we get the answer saying that unobjected to statements or excited utterances by the defendant on a 911 call played during the state's case in chief would be sufficient predicate for that overt act to raise self-defense and allow prior acts into evidence during the defense cross of the state's witnesses during the case in chief. I'm not prepared to make that ruling today, so I'm not saying that the WhatsApp messages are not admissible. I'm just saying that I don't think they're admissible at this point. So that's my ruling.
Just, Judge, for the future, if in fact these WhatsApp messages do come in another way, we would also be asking for the rule of completeness, the rest of what was taken out, we added that.
Well, that's why I mentioned earlier, because you certainly, there may be other ones that you want to introduce.
Right, so I just to put defense on notice that may be an issue.
So we're going to bring the witness back in, and you can resume your cross.
So that the court doesn't run the jury in and out for naught. I've shown Suzanne the remaining aspect of my cross, anticipating there may be some objection to it.
And I would have an objection.
You do? Okay, can you step back out?
Sure.
Same rules.
Judge,
Yes, ma'am. The witness is out.
I'm trying to interpret this as fast as I can, but this, and maybe the defense can confirm, I believe these are supposed Google searches or internet searches for certain subjects
Yes.
that are on
Yes,
Ms.
that are on
Benefield's
the phone,
And
that of which was extracted by this witness.
there are things like, ask Amanda, how do I co-parent with an abuser? Co-parenting versus parallel parenting with an abusive ex, the Good Men Project.
Can you give the judge the date of those?
The first one was, I'm sorry.
2020, Your Honor.
The first one was 5/11 of 2020. That was the Ask Amanda, how do I co-parent with an abusive, with a parent with an abuser. The next one was the same date, and that was co-parenting versus parallel parenting with an abusive ex, the Good Men Project. Same day, 6 tips to help you co-parent with an abusive ex. And then there appears to be what I would assume is one of the Bible verses that was sent
Yes.
by Doug Benefield, which says, "For the wages of sin is death, but the gift of God is eternal life in Jesus Christ our Lord." Romans 6:23.
Yeah, that one was shown by the state. They just moved past it a little quickly.
So, Judge, I have several objections to this. First, what is the relevance of her searching for these things? Second, she cannot just put on information that she was looking for abuser information without taking the stand and saying that she thought he was an abuser. And also, by her entering this on her own behalf, it's hearsay that she's typing in these things as she's searching. So I would object to any of this coming in.
Okay, relevance. Let's see, Your Honor. These are 5 internet searches on the phone that Sergeant Keyless extracted. First of which is on May 11th of 2020. And the subject is domestic parenting with an abuser.
I'm sorry, it's a search or it's an article?
It's a search, an internet search. This is Ashley Benefield, who, according to the state, as the court knows now, killed her husband to stop the release of Dr. Baroda's report. A few months before the shooting, searching the internet for how to co-parent with an abuser, and then again on 5/11/20, ask Amanda, how do I co-parent with an abuser? On 5/11/20, co-parenting versus parallel parenting with an abusive ex, the Good Men Project. And 6 tips on 5/11/20 to help you co-parent with an abusive ex. So, the relevance, I think, is acute. Our whole theory of defense is that Doug Benefield was an abusive spouse. We have been denied the opportunity to introduce any evidence of that at every turn based on 2 rulings by the court. The first being the predicate. Once the 9/11 tape came in, which said my husband attacked me and I shot him, together with the swollen eye and the scratches, as the case law says, I think that may certainly qualify for the slightest evidence.
I just ruled on that.
All right. Then we find ourselves now in the same position as the ruling that the court just made, excluding the text messages of Doug expressing
Hold on.
a murderous...
You said I excluded them? I did not exclude
You're
them.
not allowing me to introduce them.
I said not now, at this point.
So that's excluded, at least at this point.
Okay, go ahead, sir. I'm sorry for interrupting. Go ahead.
Now, I find myself in the same position, except now the evidence is much more acute and much more corroborative of an abused woman's fear. Here we have, in her quiet, most private moment, what is she doing 5 months before the shooting? She's searching the internet about how she is to get along with an abusive ex-spouse. If that doesn't go to her state of mind about fearing Doug Benefield because he's abusive, I don't know what does. Now, procedurally, I can't provide the court with a case that says you're not allowed to introduce such persuasive evidence in the state's case. But again, I take the position, Your Honor, that the state should produce evidence that says I can't. And if they don't produce that evidence, then I think, at worst, it's within the court's discretion. And I think it would be an abuse of discretion to not allow me to introduce this evidence when the state's whole theory that they just spent an hour and a half with this witness was establishing how well she and Doug Benefield got along in the week prior to the shooting. I've told the court several times now, that's the whole MO of an abused woman, is to get along and go along and act like everything is okay. That's why both Broder and Quintal have told the court and told the jury, yes, Miss Benefield was different. She acted differently when she was here and she saw me with Doug. At that time, she would always act deferential, but when she was by herself, she let me know, I don't want anything to do with this relationship anymore. So, Your Honor, I think in the interest of justice and fundamental fairness, I should be entitled to ask this witness to identify this information, which came in the same extraction he did for the state for the last hour and a half.
State response?
Judge, the reason this should not come in is the exact same reason that you just ruled on the last issue. There are other reasons if it becomes relevant, if it becomes admissible, but that would be my reason now.
Could I please see the exhibit?
Of course. May I?
And the purpose of offering Defense Exhibit 4A is to prove that Ms. Benefield actually made those searches?
It's not being offered for the truth of the matter any more than the state's exhibits that Sergeant Keyless went through are being offered for the truth of the matter. It's being offered for the identical reason. This is part of what was on her phone. It shows her state of mind prior to this incident, and it is relevant to the defense. In fact, it's the backbone of the defense.
Previously, I had made the ruling that the text messages were admissible not for the truth of the matter asserted, and I was not asked to give any sort of limiting instruction, but I believe I had previously either I expressed that or during a ruling or put that in a prior order. The admissibility of those items and documents was established through the state's case. Let me start here. Three things for admissibility of evidence: authenticity, relevance, and admissibility. So the authenticity for the text that we're talking about, the potential internet searches and so forth, the state provided that case. It came, the testimony is that it came directly from either Ashley Benefield's phone or Doug Benefield's phone. And the case provided by the state, I don't have the site in front of me now, that the authenticity was established by the technical services officer explaining when and how he downloaded them. But authenticity doesn't automatically mean admissibility. They still have relevance and admissibility. relevance. I understand what the defense is saying and how it's relevant to their case. And we've had this discussion on a number of pieces of evidence that the defense is trying to get in. And I understand how they're relevant. I understand the arguments, but I cannot blindly disregard the third prong, which is admissibility. And just because it helps a case or hurts a case doesn't make it admissible. I'm trying to think of, I know you're saying you're not offering it for the truth of the matter asserted, but I can't think of any other reason to put that information, these internet searches, in front of the jury, but to show that Ashley Benefield made these searches on a certain day. And so it's an out-of-court statement used to prove the truth of the matter asserted. I'm happy to consider case law if you have some that says that I'm wrong, but that's the definition of hearsay. So at this point, I'm going to rule that they're not admissible.
I have no further questions of Sergeant Keelis. I would like to make a proffer, if I could, for the record.
Of course. Do you want me to call him back in for the proffer, or are you just going to proffer?
No, yeah, I'm just going to read Defendant's Exhibit 2, or anticipated Exhibit 2. These were text messages that were downloaded by Sergeant Keelis.
Judge, can we just copy that and put that into evidence?
Yeah, can you show a copy to the state?
He did.
Oh.
But if we could just make a copy and enter it in.
Oh, we already have an Exhibit 2, the clerk says.
Yeah, it didn't make it. I had marked it as Exhibit 2.
That's the text messages.
The concealed weapons permit? That's in.
Oh, I'm sorry, Exhibit 3. I had marked it as Exhibit 3, the text messages, and it did not make it in.
Okay, yes. These are texts from Doug Benefield's phone to Ashley Benefield's phone downloaded by the officer, right? So you want to put it in the record? All right. You don't have to read it. I mean, it's going to be in the record. So that's 3. Did you also want to do 4A?
Yes, positive.
State, for purposes of the proffer, do you believe that Detective Keelis would testify that he downloaded Defendant's Exhibit 3 and 4A from Ashley Benefield's phone?
I believe would. Judge, I don't know specifically with the second exhibit specifically because I haven't investigated that, but I would assume yes.
All right, is that sufficient for your proffer?
Yes.
Do you want Keelis to stay under subpoena? Because I want to give him the right instructions.
Yeah.
All right, can you have Detective Keelis come back in? I'm so focused on getting his name right, I keep forgetting his title.
Judge, if it
actually
makes you feel
Sergeant.
better, it took us about 2 weeks to get it.
It just looks nothing like
so
that.
different.
That's why I didn't.
Sergeant, I'm sorry. Just right in front of me. Sir, at this point, the defense has no further questions for you, so I'm going to be able to let you go for today. However, you have not been released from your subpoena, so all the instructions I gave you regarding sequestration of witnesses still apply. You may not discuss your testimony or the questions asked of you with anyone, including the attorneys or other witnesses. You can't discuss with other witnesses what their testimony was or what questions were asked of them. And to the extent that this trial is out there on the internet, you're not to watch or listen to anything related to it, including news reports. Do you understand? All right, sir, you're free to go now. If one of the parties calls you, you need to respond. Thank you. Hold on. All right. The clerk needs us to be clear on your proffer. Mr. Taylor, we have Exhibit 3, which is the
Text message.
the What's Now apps, WhatsApp messages. All right, that's document 3, but it's got multiple pages. 4A is not just 4A. It's 4A, 4B, 4C, and 4D. So we have composite 4 with A, B, C, and D. And then actually you had 5 was the Bible verse.
Yeah.
All right. Well, the Bible verse, that's already in.
Yes.
I'm not denying that at all. Do you want?
I'd like to have it on there because they showed it.
Yeah.
They showed it.
STIP, Defendant's Exhibit 5, which is one of the I think this might have been the last one or one of the last ones.
Yeah.
All right, so there's a stipulation to the admission of Defendant's Exhibit 5, so that's in. Catching that.
Well, it's,
Right, 5 is in, 3 and 4 are proffers.
you say, Your Honor, that Exhibit 5 is in for purposes of proffer.
No, for evidence.
It's not going to do me any good as a single exhibit, Your Honor. I'd rather it be part of the composite. The court's ruled that it's not admissible. And
No, I'm ruling 5 is admissible because it was shown. State, you showed it.
Right, it was shown.
So this is just a printout of.
Okay, but I think he hasn't. Do you want it admitted?
the witness is gone.
So maybe 5 should just be with the composite number 4 and not entered. Just be at as a proffer.
All right, so I'm saying I would receive 5 in evidence. There's been a stipulation to it, but I'm not receiving it?
Correct.
Okay. I just don't know what its status is then. All right. All right, Sadie, you ready to call your next witness?
Yeah.
Ready to bring the jury in? All right, let's bring him in.
And I think we are going to use I know you just opened the blinds, but.
Welcome back, everybody. Did anybody begin deliberations amongst yourselves, talk with anybody outside of the jury about the case, or do any research, or hear anything about anything we talked? All right. When we were last here, Detective Keelis had finished his testimony, and now we'll let the state call their next witness.
Today we call Dr. Vega.
Solemnly swear or testify about the whole truth and nothing but the truth.
Yes, I do. Thank you.
Hello, sir. I'm Judge White. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It just does adjust up, down, left, and right as you need. Speak in a loud, clear voice. We should hear everything.
I will. Thank you, Your Honor.
Good afternoon, Doctor.
Good afternoon.
Would you please state your full name and spell your last name for the record?
Certainly. My name is Russell Scott Vega, last name spelled V-E-G-A.
And how are you employed?
I'm the Chief Medical Examiner for the 12th District of Florida, and that includes Sarasota County, DeSoto County, and here in Manatee County as well.
And how long have you been a medical examiner?
I finished my training in 1997, so more than 25 years.
And how long have you been the Chief Medical Examiner?
Here, so October 1st will be 21 years.
And you said here, were you a medical examiner somewhere else?
I was an Associate Medical Examiner in Hillsborough County for 4+ years.
And what kind of education do you obtain to become a medical examiner?
Well, I mean, it's different from person to person a little bit. I can tell you my own personal experience.
Yes, please.
Certainly. So I did my undergraduate studies at Florida State University. I majored in physics and biochemistry. After my undergraduate, I went to medical school at the University of South Florida. I graduated from medical school in 1990. Following that, I did 2 years of training in general surgery and then 4 years of training in anatomic and clinical pathology. Pathology, it's a specialty of medicine that focuses on how to diagnose diseases based on looking at cells, fluids, tissues, biopsies, organs, and by doing autopsies. Finally, after all that, I did a 1-year fellowship in forensic pathology. That's the subspecialty which really focuses on performing autopsies and doing death investigations.
Thank you, sir. And what are your current duties as a Chief Medical Examiner, or at least, yes, as a Chief Medical Examiner?
So as the Chief Medical Examiner, I administer the office here. So I manage the staff, I set policy, do procedures, and I do some of the casework myself. So I do some of the autopsies and death investigations.
So you do still conduct autopsies regularly?
I do.
And do you know how many approximately autopsies you've conducted in your lengthy career?
I don't know exactly. I suspect it is getting close to 4,000.
And of those, can you have any involved gunshot wounds?
Very many.
And so that was my next question. The percentage, do you think it's a lot?
Yeah, I can't tell you the percentage, but I've examined many hundreds of gunshots.
Thank you, sir. And I'm going to draw your attention back to September of 2020. Did you conduct an autopsy on Douglas Benefield?
I did.
And when did you do that?
The autopsy was performed in the morning of September 28th of 2020.
And can you explain how your procedure for conducting an autopsy?
Certainly. And I don't think my procedure is greatly different from other medical examiners or forensic pathologists. But the procedure starts with the examination of the body in its state as it arrives, at our facility where the autopsy is performed. That includes documenting the condition of the body with photographs and diagrams and written notes. Following that, if there's reason for evidence collection, that's going to be in concert with a law enforcement agency, then evidence collection ensues. After the initial part of the examination and the evidence collection, then there is a more detailed examination looking for identifying characteristics, changes that might represent natural disease, and then any injuries that are present. After all of that, then I think what many people might consider the traditional part of the autopsy begins, which is the internal examination where the body is examined internally for, again, the same kind of changes of injuries and natural diseases.
And is that the process you followed in the autopsy of Mr. Mr. Benefield?
It is.
And during your autopsy, are photos taken to document injuries found, if any, on the body?
Yes.
And in this case, of the autopsy of Mr. Benefield, were pictures taken?
Yes.
Your Honor, may I approach the witness?
Yes.
I'm showing you what's been pre-marked as states 86 through.
Can I see the photographs, please?
Yes, they're the same as the ones you just looked at them.
So there's 3 photographs, Your Honor, that I have an objection to.
Okay.
Well, she's going to put them back in order for me while we do that. During your autopsy, did you determine the height and weight of Mr. Benefield?
I determined the height and the body length, as that's what we measure with the body reclined on the table. I think it's a very close approximation to height. It might not be exactly the same.
Yes, sir. And what was Mr. Benefield's weight at the time of his homicide?
It was 169 pounds.
And the length?
The body length was measured to be 69 inches, or 5 foot 9 inches.
Thank you for converting it for me. And during your external exam, as we discussed, those injuries are documented in these photos as well. Is that correct?
Yes.
Okay, and I'm going to now show you. Sorry, Judge. Here we go. Dr. Vega, we're going to try this one more time. I'm going to show you 86 through 97. Would you mind taking a look at those photos and telling me if you recognize them?
Yes, I do recognize them.
And what are they?
These are photos taken at the time of the autopsy of Mr. Benefield back in September of 2020.
And do they fairly and accurately depict some of the injuries and some evidence that was as they were in September of 2020?
Yes.
Thank you, Your Honor. Thank you. Your Honor, at this time I'd ask to enter states 86 through 97.
Okay. Received.
Thank you. And generally, when you examine Mr. Benefield's body, did you find injuries on the outside of his body?
I did, yes.
And where were they? And we'll talk about them in detail, but generally, where were they?
There was an injury to the right side of his chest, there was an injury to his right shoulder, and there was an injury to his right leg.
And did he have any injuries to his face or head?
No. Well, he did have to his head. Yes, I'm sorry, not his face.
And what type of injury was that?
The injury to his head was what we would typically call in medical terminology, we'd call an abraded contusion. That's a swollen and scraped bruise. And it was on the very back of his scalp at what we'd call the occipital protuberance, or the lump at the very back of the head.
And what would that type of injury be consistent with?
Typically, it's from falling backward and striking the head.
And when you were looking at his external injuries, did you have some opinion as to what had caused them, specifically the chest and the leg?
Yes.
And what did you feel that they were?
They were gunshots.
And did you then conduct an internal exam?
Yes.
And did that internal exam confirm what you felt about that they were gunshots?
Yes.
And I'm going to display behind you states 86. And I believe this is generally what we call an identification photo. Is that correct?
That is correct.
And is that Mr. Benefield as he was in September of 2020?
Yes.
Thank you. Okay, then let's first talk about the injuries you said he suffered to the chest. You said that was a gunshot wound?
Yes.
And how many defects in his body were associated with the chest wound?
There was one defect, and that was on the upper right side of the chest.
And is that what we see here in states 87?
It is, although we're also seeing the injury to his right arm area as well. Actually, that's the one that has the marker on it. The chest injury is just above and to the right of that, at least according to the viewpoint of the viewer of this photo.
And for orientation purposes, this is his right side of his body?
It is, and I'll use the laser pointer to indicate. This is the arm injury, that's the chest injury, just to the right side of his right nipple.
And was there, you said there was only one injury. Does that mean this is an entrance wound?
That's correct.
Was there any, and there was no corresponding exit?
That is also correct.
And did you locate a projectile that was associated with this chest wound?
I did.
And where was it?
It was lodged in the tissues of the left side of the back.
I'm going to show you states 88. I believe that's a close-up of the injury we saw on his chest.
It is.
And then can you kind of orient the jury as to what we're looking at in States 89?
Yes, this is the back of Mr. Benefield's body. He has been rolled up onto his left side. So what we're seeing here is his back, the head here. So this is the left shoulder. The right shoulder would be up here. This is the left side of his back, and it's this purple area right here that represents where the projectile was lodged under the skin and tissue.
And did you remove it?
I did.
I'm going to show you 90. Is that the removal process for the projectile from Mr. Benefield's body?
It is. In order to visualize it and then remove it, I made an incision in the skin, which you see here, and then just for documentation purposes, I reflected the skin with the tip of the scissors so that we could photograph the projectile in place in the tissue prior to its.
And Dr. Vega, I'm sorry, I'm going to go back to States 89. Where you described his body, but there's some skin discoloration. Can you explain to the jury why his skin looked red or darker?
Certainly. That is what we call lividity. Lividity is the settling of blood in the tissues that occurs after death. The heart's no longer pumping, and the major force acting on it is gravity. When somebody's lying on their back after death, which is typically what we see, we are of the usual process of putting somebody on their back in a dignified position after death. And so the blood typically does settle into the back, and we see this purplish coloration here, which is a result of that. There's some here as well. This area here where there isn't any discoloration, except bullets, is because this is where the table was pressing up against the skin, and that pressure kept the blood from settling in those areas. So most of this purple discoloration is lividity, with the exception of this area right here, which is due to a little bit of bruising associated with the placement of the bullet there.
And Dr. Vega, I'm going to show you what's in our state.
Yes, I do.
And how do you recognize it?
This is the projectile that I recovered from the back that you see in the photograph you had up previously.
And other than having been repackaged for trial purposes, it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's back.
It does, yes.
Your Honor, at this time, the state would ask to enter States 14.
Objection received.
And Doctor, I'm going to show you States 95. Is this the same projectile that you have there in States 14?
Yes, it is.
And what, if you know, is that red part that's next to the projectile?
This is a small rubber plug that is occasionally found in certain hollow point type projectiles. Not all hollow point projectiles have these rubber plugs, but it's part of the process of creating this hollow point that allows the projectile to expand and deform, as we see in this case here.
Thank you. And so going back to the location of the projectile, based on where the entrance wound was and where you found the projectile, did you determine a path of travel that projectile took through Mr. Benefield's body?
I did.
And what was the path of travel?
So the path of travel was one of entering the right side of the chest, striking the fifth rib on the right side, the right lung, the 10th vertebral body on the in the middle of the spine, then the left lung, the 10th rib, and then the soft tissues of the back till it stopped where it is. And that path then, if one were standing upright and straight, would be from the right side toward the left, from the front towards the back, and essentially horizontal, in other words, without angling upward or down. And again, that's relative to a standing upright position.
Yes, sir. And would you mind, would you be so kind as to stand up and kind of point on your body where the entrance?
Certainly.
And where would the exit be?
Well, no exit. But
I'm sorry, the projectile.
The projectile,
Yes, sir.
my mobility is a little limited, but essentially would be in the back over where the tip of my thumb.
Thank you. And would you just turn back so we can see the entrance again?
Yeah.
Thank you, sir.
You're welcome.
More continuing coverage is on the way. The Black Swan murder trial of Ashley Benefield from the Hidden Killers podcast and True Crime Today. Press subscribe now.